Hey everybody, I'm Jesse Weber and welcome back to Law and Crime Now. We have a big show today. We're going to be focusing on the latest developments in the Vallow Daybell case, as well as the Robert Durst trial. Let's start with Lori Vallow. Now, again, this is that Idaho mother who's been charged in connection with the disappearance of her two children, 7-year-old Joshua J.J. Vallow and 17-year-old Tylee Ryan, both missing since September. She's been charged with everything from child abandonment to ultimately solicitation and contempt. Now, Friday was an interesting day. Here on the network, we covered her bail reduction hearing. Now, their defense attorney, Mark Means, filed a motion to have her bond reduced from $1 million. And he cited everything from, hey, given COVID-19, it's really hard to make that unreasonable sum. Also, it should be noted that he said he believes his conversations with his client while she's in jail are being secretly recorded and disseminated. That's a big accusation here. He says she needs to get out of jail so he can have a privacy and private conversations with his client. Well, if you haven't seen it, this is what the judge had to say about that motion to reduce the bond. Take a look.
I would certainly invite evidence that conversations are being inappropriately recorded between counsel and client of any sort, whether it's Ms. Daybell or anyone else, to be brought to the court's attention. I'm not sure a motion to reduce bond is exactly the way to do that, but certainly we don't want that happening, and I'm confident that the jail will make sure that that doesn't happen. I happen to believe that Mr. Wood and Madison County Sheriff's Office have great motivation to make sure they don't do that in this case or any other, because it is a serious violation of constitutional rights. And if it actually has occurred, as Mr. Means speculates that it might, and I guess what I should say when I say that if it's actually occurring, what I mean is if conversations between an attorney and client without a warning that they're being recorded are actually being recorded, then that would certainly be something that I would want to know about. But I don't really have any evidence that that is actually what is going on here. So on that basis, I'm denying the motion for bond reduction because I cannot find any good cause to reduce bond further than it already has. And I would invite Mr. Means to consult with local defense attorneys who I'm sure have come up with alternatives during this time, and then also have a long track record of dealing with Madison County Jail. I'm aware that different jails can have very different procedures, and I'm confident that there are a number of defense counsel in Madison County that would be willing to talk to Mr. Means about ways to surmount any virus problems at the jail in regards to communicating with clients.
Okay, so as you heard, that bond reduction not happening. She is still in jail on $1 million. Let's bring in my guest right now, a familiar faces. We got Law and Crime fellow host, Terri Austin, as well as executive trial producer, Cathy Russon. It's great to have you both here. Terri, why did the judge make this decision, and do you agree with it?
I do agree with it, Jesse. She made this decision because she could not find good cause. She said that they can do something else other than reducing the bail here. They can make sure that they talk to local counsel. Local counsel can tell them ways to have conversations with the client without risking letting the defendant out on bail. So I think she made the right decision. She is a flight risk, if you ask me. And the fact that she did not produce her children when she was ordered to, she should stay in jail, and she and her attorney should figure out another way to communicate.
Terry, but the thing is if you listen in the news, there are other high-profile defendants who are kind of getting some relief because of COVID-19. And here, the idea that $1 million is a pretty high bond. She's not charged with murder here. Do you think that's, I mean, is that fair given everything that's going on? And on top of the allegation that these private attorney-client privilege conversations are being recorded, the prosecutor, who we're going to get to in a little bit, admitted that some of those conversations were recorded. Now, it's a separate question of should Mark Means, who represents Lori Vallow, should have known that these conversations were being recorded is one thing, but there seems to be a serious issue here that the judge was taking account of.
Well, I do believe that all defendants have a Sixth Amendment right to representation. They have a right to privacy, but I understand, as far as I'm concerned, there's 6 people who are either missing or dead. Yes, she's only been charged with abandonment and not paying child support at this point. But when you think about the reality of this situation, I think the judge is taking all of that into account. She has not said where her 2 children are. And if she knows, she should certainly say this. So I think she should be in jail for now.
Let's go back to Mark Means, okay? Because he was a central focus on Friday. This is Lori Vallow's attorney making that argument that I just described. Take a look.
And so I relied upon that representation to have that communication. My gut was, I think they recorded it. I heard beeping on the phone that I don't know if it was a cheap landline. I don't know if it bumped my ear, because as I sit there with the ear pinned to my shoulder, typing on a laptop, trying to show documents to my client, it's extremely difficult. So I go back and I file the amended motion before the court, bringing up my belief that I think it was recorded, even though I was told repeatedly on each time I was there that it would not be recorded. So I file that motion. Now, fast forward, the prosecution does not file a response. They do not call me after I file that motion. They do not make contact with me and say, yes, Mr. Means, we accidentally recorded it, but we've deleted it. We've done what we needed to do, or whatever it is that they were going to do as far as handling it. They file a response on the 13th, give or take 2 hours before our informal conference, and they admit in a statement as an agent of the court in their paragraph, and I believe it was paragraph.
I'm looking at the first objection to your amended motion of April 7th. Is that, are you for, you said April 13th, so I'm trying to.
Yes, Your Honor, I'm sorry, it's April 7th. And in that, paragraph 5, the state represents in paragraph 5 to the court that the attorney, that they learned, and this is where it gets unique and these affidavits come into play, that one conversation between the defendant was accidentally recorded. Okay? They admit it. This is a filing by an agent to the court on that day, on the 7th, before that hearing. Now,
okay, so I want to go to you, Cathy, because you watched this with me, but you were also following our trial watchers, our chat rooms. What's the general perception of Mark Means, Lori Vallow's attorney?
They're not impressed with him at all. We looked up his practice, and he doesn't have criminal law or defense. He's not a criminal defense attorney. He's a family law attorney and personal injury and bankruptcy attorney. I don't know what the connection is. I don't know why, because he is now representing Chad Daybell, who hasn't been charged with anything, and Lori. They're using one attorney, and it's him, who does not specialize in criminal law. And I'll tell you, he got slammed on social media and in our chat rooms during the hearing. He rambled on for a long time.
Yeah, and I don't think he could be too surprised at that, considering he said in open court, look, I'm not a seasoned attorney. We're going to talk more about Mark Means, and when we come back, the Dateline special on this whole case. Stay tuned.